So what are we doing on this one? Your name, sir?
Defendant.
So he's pleading to, let's see, the resist and obstruct is going to be dismissed, correct?
Yep, and reduced to a disorderly, and he's going to plead as charged to driving unsuspended.
I see. Is that what you want to do, sir?
Yes, Your Honor.
If you plead a disorderly person, possible penalties are up to 500 fines, 90 days jail, costs are all those. If you plead to that, and you plead to the driving on a suspended, which is punishable by up to 500 fines, 93 days jail, costs are all those, I'm going to go ahead and dismiss the resist and obstructing officer. Do you understand that?
Yes, Your Honor.
And did you sign, read, and understand an advice of rights form here today?
Yes, I
You
do.
plead guilty, you'll be giving up all those rights, and we're not going to have a trial. Do you understand that?
Yes.
To the charged disorderly person, how do you plead?
Guilty.
To the charged driving on a suspended, how do you plead?
Guilty.
Were you operating a motor vehicle February 19 to 25 at or near 23307 Telegraph Road in this township of Brownstown?
Yes, I
Was your license suspended?
Yes, I
Are you on probation or parole?
I am now. I wasn't at the time. I am now.
But you weren't then.
No.
To the charged disorderly person, how do you plead?
Guilty.
Were you at that location on that date and time?
Yes, I was.
What did you do that makes you guilty of disorderly person?
Officer was, I felt like he was gonna pull me over, so I pulled into the bar parking lot, and I got out of my car. When they came in, I went in the back and hit in the back.
All right, so you did that to avoid.
I thought I was gonna get pulled over.
Did they tell you not to go inside?
No. They,
Where do we get the
Your Honor, can I have one?
Yes.
So Mr. Benson, you indicated that you saw the police behind you.
yes,
Do you think they were attempting to pull you over?
I thought there was, yes.
Okay, and then you stopped your vehicle and exited
Yes,
and went into a bar?
yes.
And,
Evasive.
okay, evasively, and, so there were other people at the bar?
Yeah,
And I guess was the public peace disrupted
Yes.
by the police having to chase you out?
without question.
Satisfying.
I'll accept your pleas. How's his record? I'm gonna just accept the plea to suspend, accept the plea to disorderly, dismiss the R&L. How's his record?
Got a few things on it, Your Honor. He has a case pending that he anticipates probation for. He has.
Let's do
currently
this.
on probation.
Let's do this. I'm just gonna order a pre-sentence report, okay?
I should add that Ms. Boley Carter indicated she would not object to my request for fines and costs and for possibly community service in this matter. Mr. Benson is about to be on probation out of 2 different jurisdictions. Is that accurate, sir?
Yes.
Well, I'm not saying I won't do that. You can remind me of that at sentence, but I'm gonna still order a pre-sentence report.
Okay.
And you wanna do the 16th, Heather?
Yes, yeah, that's a Brownstown, correct? Yeah, sorry,
Yes.
just I had to check myself. Yeah, we can do the 16th.
Let's do the 16th at 8:45, okay? And you can go ahead then, and go down the hall, get your notice, and then go over probation where you'll be interviewed, okay, sir? Any questions?
Your Honor, we have a.
He also has a no insurance, by the way,
Yeah, I believe that.
okay?
And Your Honor, he does have a companion case with Judge Hudson that the prosecutor dismissed as part of this global resolution. Judge Hudson wrote on the ROA that she would have you dismiss that on the record.
It's here. I thought Judge Hudson already dismissed it.
Yeah.
Here.
You want it both done.
Okay.
She wrote.
So yeah, as part of this agreement, it was going to be a dismissal, and it looks like she did it down there, right?
She didn't do it on record, Mr. Benson is.
All right, was this a global resolution with
Yeah.
25B148174? Yes, it was.
Yeah.
Case dismissed. That case is dismissed.
Thank you so much, Your Honor.
All right, thanks. So good luck, sir. We'll see you back here. I just need to, we're gonna set this other case for a show cause. You should bring the money on this one. I'm gonna set the no insurance C file on that date, Heather, too, okay?
Your Honor,
Okay,
the
Judge.
output on that.
It-
Should be 327.
I think that one's 362 with the suspension. Yes, it
Yeah,
is.
362 with the suspension. I mean, with the suspension, yeah. Yes.
Judge, I'm sorry, was that case for Judge Hudson ending in 174? We're dismissing that one?
Yes.
Yes.
Okay, thank you.
Thank you. Okay?
Thanks, Your Honor.
Thanks. Good luck.
Okay.
Thanks. Bologna.
Good afternoon, Your Honor. Anthony Bologna, Veteran City Trial.
So I'm not gonna make an issue of it. Your motion was filed yesterday. You can respond verbally, Mr. Bologna,
I
okay?
appreciate that, Your Honor.
Okay, go ahead.
So we received the motion this week. And then our response would be that,
Well, wait, let him argue first.
I go for it.
Go ahead.
Okay, let me go first?
Yeah.
Okay, my motion. All right, thank you, Judge. I think it's self-explanatory, the motion. I believe it's right on point respectfully. We want, the court rule says about the interest of justice prior to sentencing, about a motion, if the plea itself was not defective, by the court or by the attorneys, which we're not challenging, we're saying the interest of justice is the standard by court rule. And that is, it's almost, I wish all my cases were so clear cut, at least in my opinion. And that is, if somebody is a diabetic, and the law and the science is crystal clear that taking a breathalyzer is just not accurate. In fact, the officers are informed on their sheets that if somebody's a diabetic, not to get blood. And also, the statute, I don't have it right this second, but I could have it in a second, that only is blood and urine is permitted, obtaining a reading for blood alcohol content when somebody has diabetes. And it's crystal clear my client has diabetes. We have all the medical records for that. I didn't, I want to say sealed. I didn't want to provide those to the court. He can swear to it. His doctor has a letter that says that he's a diabetic. In fact, the letter says that it can cause artificial highs, not negatives, but positives, in taking any type of a breathalyzer reading. And that's why it's blood only. So, Your Honor, I don't fault the officers. Of course, they gave a breathalyzer. But in the interest of justice, this is a very important case for my client, like it would be for anyone. And he's a medical doctor, and licensing to that. And so, it was a .09 and a .10. And if it was artificially high, what was his real blood alcohol level? 0.02, 0.03, 0.04 maybe, and it's artificially high. So in the interest of justice, and Judge, I've been 40 years, but however long the court's been on the bench, I presume about 30, is that I've never brought a motion like this in this building. And so I truly believe that we have good cause in the interest of justice by the statute or by the court rule, that it would be not fair to set it aside prior to the sentencing and allow him to proceed to trial. In the event the judge was Your Honor was kind enough, for lack of a better word, to set it aside and set a trial, that would be a for sure trial date that would go. I don't expect it to be any more at all than a one-day trial. Thank you.
Mr. Bologna?
Thank you, Your Honor. Yes, I received the motion yesterday afternoon. I think for allowing me to respond orally. We were here, Your Honor, as we recall, spent quite a lot of time trying to resolve this matter. We came to what we thought was a good resolution ultimately in this case. The plea was taken. The officer was here on that date. That officer is no longer, that officer is no longer a Trenton officer, so we had a subpoena to get him in here. We were ready to proceed for trial on that date, and we both thought we had a resolution reached. As far as the whole argument regarding diabetes, that's a fact issue. I believe the officer, likely being the officer that it was in this case, probably asked if you have any medical conditions prior to administering anything. All that said, Your Honor, will ultimately the court's discretion, but the city was prepared to go on trial, or to go to trial on the date that it was actually set. So that's our position on it.
Your Honor, let me just, quick reply. And that is, my client was never advised against the attorney. Unfortunately, I don't think practice that area of the law, at least beyond pleas. That is very important, and it's instrumental and material and give you a breathalyzer that if you have diabetes, there'll be acetones, and I put a little bit more of the scientific terms in the motion. Thank you, Your Honor.
Anything else, Mr. London?
Better.
Acceptance provided, this is under 6310B. Withdrawal after acceptance but before sentencing. Acceptance provided in subsection 3 after acceptance but before sentence. A plea may be withdrawn on the defendant's motion or with the defendant's consent only in the interest of justice. It may not be withdrawn if withdrawal of the plea would substantially prejudice the prosecutor because of reliance on the plea. I don't know that it would substantially prejudice the prosecutor, but I can't find that this is in the interest of justice. As Mr. Bologna pointed out, there were lengthy discussions that occurred on the date of the trial. There were numerous pre-trials. I remembered when you said sidebar, Mr. Kolovis, when you were here for sentencing, that this was based upon the fact that, primarily, that this was based upon the fact that he was a diabetic.
Correct.
I had read the report, which I never do. I'd read the police report, which I never do before there's a conviction. I'd read it the date of the sentence, which I always do when I'm going to sentence somebody. And if you look at the report, it says, Pastor informed me he did not suffer from any injuries other than some back pain. He denied being a diabetic. He stated that he had no recent head injuries. He stated that his highest level of education obtained was a master's degree. He informed me he could understand everything that I was saying. So while your client is now advancing this argument, or you are, I suppose, on behalf of him, the police report clearly indicates that he told them that he was not diabetic. I'm sorry, I'm going to deny your motion.
Just I need to for the record, just make a record. And Your Honor, he did not say that. And it's on his listing of his medication. And there's a letter from his doctor talking about it.
I don't know how they're supposed to be mind readers.
But even if they,
Listen.
nobody says they are. Nobody says they did anything wrong. I'm just
It
saying.
says he denied being a diabetic.
That doesn't mean the results.
That means that they might have taken other steps. And this is a decision I'm not gonna reverse myself on. I've thought about this. The interest of justice do not require setting aside the plea. I will be happy to let you appeal this. I will sentence him. You can file your motion to stay any punitive measures pending the appeal. I'll be happy to do that for you.
You don't judge. What if somebody gets raped and they're serving 50 years in the DNA contact? The person said, I'm
Mr.
guilty.
Globus, I heard you. I made my decision.
Doing my talking. All right.
Do you want to sentence now? You ready for sentencing?
Your Honor, I would ask this. May we be allowed to do an interlocutory appeal?
No, I'm going to sentence.
You want to sentence?
Yeah, you can take your appeal and you can do, I will stay whatever's punitive.
I appreciate that, Judge. I suppose go ahead and
Okay,
with sentencing.
all right. So if you had a chance to review the report with him, are there any material additions, corrections, or deletions?
If I may have one.
Sure.
No? Yeah, go ahead. I understand your prescription.
Listen, Mr. Pastor, you guys can take an appeal. I'm not trying to jam anybody here. You told the police, according to the report, you denied being a diabetic. I don't know what they're supposed to do. Now either the police officer is lying in a police report, listen, I'm not gonna listen to this anymore. I made my decision. Nobody has ever heard me say I'm always right. Not one person's ever heard me say that. I'm moving on. We're gonna sentence. And then you can take your appeal. I have no issue with that.
Thank you.
All right, is everything in this report accurate?
Yes, Your
No material
Honor.
additions? Okay. Anything you would like to say on his behalf?
Your client, my client is a medical doctor. Medical profession. And he runs several offices with his wife, who's a medical doctor. He denies, and I understand the plea of guilty to appear, but given the other circumstances now that he relied upon, he denies that he was under the influence that day. Thank you, Your Honor. Nothing further.
Sir, anything that you would like to say before I sentence you?
I got prescribed that for me. Best year and a half. Got all my prescription. Nobody has ever asked me. I do not recall the officer has asked me. Now I'm diabetic from now.
Can I see your AA attendance?
Right.
Pardon?
He may have it at the top. Do you want him to go to the car?
Do you have them in the car? Have you been going twice a week?
Yes, I will. Here. I got it. Can I go to my vehicle?
May he go to his vehicle, Your Honor?
Sure.
3 minutes.
Sure.
I think you want to run up there and look at it. I'm respect. Real fast.
I'll tell you what, come on back up here. Let's just finish the sentence. You give them the probation afterward, okay?
Big good.
All right, anything else, Mr. Pastor?
No, I'm not sure if any of my medical letters was being presented. That was one of my main concern because of the fasting with ketone levels at that time, and I had to prescribe 1,000 milligrams of metformin. I got my prescription history for the last 2 years. I just emailed it to Mr. Rose. I've been prescribed for diabetic medications, but I take every single day because my weight went up to almost 200 pounds after the.
I know, but you're not gonna argue with me about my decision.
That's not my intention. And I wish this would have came to resolution way sooner, and our previous council would have presented this text as well too, which I'm just becoming aware of it. None of this was being really properly presented. And I'm very disappointed about that, because that should have been presented properly in a timely fashion. That was not my intention whatsoever to take this to this far out of context. That was absolutely not my intention. It was not my intention. I asked him to present the facts properly a number of times, and it has not taken place.
I don't know I didn't see anything that your lawyer did wrong. You didn't see anything your lawyer did. Listen to me, I don't want to quarrel with you. You denied that you were a diabetic according to the police report. Now, if somebody tells somebody that they're not a diabetic, I don't know how they could raise the defense that, yes, he really is a diabetic, he was just kidding, and they should have taken different procedures. Now, I don't want to dispute this with you anymore. I've had this feeling the whole time, Mr. Pastor, that you don't think you did anything wrong. You really don't. And you had one 4 years ago. And you're only, 46? You get one in the next 50 years, that's a felony.
We're not getting one.
Well, I know, but nobody thought you'd probably be back the second time either.
It was not my intention.
Mr. Pastor, let me finish. It's my turn to talk.
That's-
If you have something else you want to tell me before I sentence you, I will be more than happy to listen, but I'm not going to go back and talk about your lawyer. I don't see what he did wrong. If you have something else you want to say that's going to cause me to be lenient, I'll be glad to listen, but please. Do you want to say anything else?
I'm not written for anyone else. He's a such nice guy.
I don't want to talk about Mr. Zelnick.
I do not recall the officer asked me if I'm diabetic. I'm taking diabetic medication every single day. I listed on my medication sheet. I'm taking diabetic medications. I more than precisely every single day I'm taking 1,000 milligrams. It's the highest milligram of metformin you can take. That's for type 2 diabetes. I mean, literally, I was getting heart disease if I don't take that medication. I said show him my
Mr. Pastor.
He's passed that way out the judge.
And,
Not gonna upset the judge.
and you can appeal this. I've never, like I just told your lawyer,
It's here to upset you.
you're not upsetting me, but I'm not going to allow people to argue with me after.
Fire, no drugs, no cash. But somehow this case still turned into a courtroom showdown. And trust me, what starts as a simple plea deal is about to spiral into a legal debate that could change everything. Stay with me.
After I made my decision. You see that guy on the wall right now? Look at that guy. That was my father. You know what he told me when I graduated law school? Don't argue with the judge after they've made their decision. There were 3 things. That was one of them. I did it then, and I'm not going to let people do it now. 12 months probation. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. If you change your address, your place of employment, or home telephone number, you must notify probation. You have to report as directed. No alcohol, no marijuana, no illegal drugs. You're not to purchase, possess, or consume any one of those. Kratom, poppy seeds, and CBD oils are prohibited. Consuming food or other items containing those substances will be deemed a violation. You're to submit to chemical testing, PDTs, and ETGs bi-week. You're to attend AA, NA twice a week until in treatment. Once you get an outpatient treatment, you no longer have to go to AA or NA. You're also to attend the Victims Impact Panel. 5 days jail credit, 1 served, 4. I'll let you serve those as follows. 2 days on the court work program. Those have to be completed by May the 1st. 2 days court work program. We'll schedule on those, and 2 days of community service by May the 1. Fines $300, costs $300, 75 victims' rights fee, $50 justice assessment. That is 7 1/4. Screening fees $60 for 785. Probation fees are $240 for 1,025. You have cost of recovery $150 for 1,175 plus $70 in court work program fees. $1,245. You may be eligible for early discharge. If you complete all this in 6 months, you can apply. If you violate your probation, you could be revoked. You could be incarcerated for up to 93 days with credit for 1 day served. You have 21 days to appeal and 14 days to apply for a court-appointed lawyer. Now, what I'm going to do, Mr. Kolobis,
Yes.
I'm going to indicate on here, defendant need not report, and will you tell probation this, Amy, need not report. Well, look, I'm prepared if you appeal, you file a motion with me, and I'll make his fines due on May the 10th. But he's going to you can file a motion, and I will stay anything that's punitive. I'll stay which I don't consider to be AA, Outpatient Victims Impact Panel. I do consider it to be court work program, community service, or payment of fines.
Okay, thank you, Judge.
So you could file a motion when you appeal, and I'll be more than happy to stay anything that's punitive, but you gotta come in front of me, and we'll figure everything out, okay?
Consider it, Judge, thank you.
And then he's gonna go meet, still with probation, because I do need him to test. I want him to test bi-weekly, okay?
Yeah.
And I won't make your money due until May 10th, and if when we come back, I presume he's gonna file this real soon,
Excellent.
I will be happy to extend the time period to pay and to indicate he doesn't have to do court work or community service until after the appeal is exhausted.
That's very kind of you, I appreciate you.
Okay, thank you.
And patience.
Good luck, Mr. Pastor. Thank you.